Thank you. Good morning, all. This hearing is in the matter of CFI 058-2024 before His Excellency Justice Roger Stewart, KC, with the sitting of the hearing taking place in Dubai. Any orders or directions made during the course or after this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is Mr. ATUL DHAWAN, who is a litigant in person, and the defendant is Mr. RAMZI JAOUHARI, who is also a litigant in person. Thank you, Your Honor.
Thank you very much. Good morning, everyone. First,
good morning.
Thank you very much for the skeleton arguments which you have each served. What I would like to do, first of all, is look with the claimant at where we have got to in relation to the skeleton argument, and just ensure that I have understood what it is that's being said. Now, Mr. DHAWAN, as I understand it, in relation to the fraud which you allege, the fraud consists of producing post-dated checks. And what is it that you say is the lie which the defendant told you?
Good morning, Your Honor. It is not only the check is the last part of the fraud which we consider. The defendant took money from us in the beginning of the contract in advance to do a project in 1 month. And he was supposed to get the job done, and he took the money based on that. Now, after he could not even get the approvals of a municipal from the ANOC within that time. He took 1 year just to get an approval, which is unheard of. After he got the approval, and he had taken the money from me already, because he started with putting some stuff on the ground and said, pay the money, and we paid the money. That was the agreement. But what happened in 22, he called me, and when the gas and all was not being put into the system, I checked with the gas vendor because I was also connected. What's the reason? He says, I have not been paid. So that's the time we approached him and we said, you have taken the money, why you have not paid? He said, Atul, I'm in financial trouble. I've used the money somewhere else. Can you pay them and the job will be done immediately? So there was a written piece of paper in his handwriting, which was converted to an email, which was also converted to an agreement. In 22 early April, I guess, he said on 7th of April, that document is attached, that you pay the money to the vendor after he had already taken once all the money. So, and the job will be done. So we paid the money directly to the vendor with in his presence in his office, and he's given a date of 22 April 22, the job will be completed. It was not done then. He made me do the same thing at the end of the year again. And again, I had to pay the vendors to get the job. It was already being delayed by 3 years. And at that time, he had given me the check to say, okay, if I don't pay you, you have this check, you can encash it. So the check which he was issuing at that time also, he knew was from a closed bank account of 2018. And I never met him in 2018. My first dealing with him was in 2020. So multiple times he's taken money, giving a deadline to deliver the job and not do, and always threatening me, saying, if you don't pay, I don't have the money and the job will be delayed. And I was already paying a rent to ANOC. I'd already paid for 2 years, 300,000. And for the third year, I paid another 150. So 450,000 of my rent has gone waste. Well, plus the business loss.
Let me just understand this by reference to your skeleton argument. In your skeleton argument, in paragraph 4, you say the claim discloses reasonable grounds and shouldn't be struck out. And you identify in little d, fraud is particularized by objective documentary evidence. And you say the claimant pleads fraudulent misrepresentation with specificity. The defendant represented that he had insufficient funds and inability to complete the works. The post-dated checks would secure repayment should the defendant fail, and that the works were being delivered in accordance with the contract, while in truth funds were diverted and checks were drawn on closed accounts. The documentary checks and the bank dishonour memos, combined with public prosecution judgments, establish factual predicates for the fraud allegations. Now, those particulars are the only ones in your skeleton argument which you give of the alleged fraud. So he had insufficient funds and inability to complete the works. The post-dated checks would secure repayment, and that works were being delivered in accordance with the contract. So you presumably are saying that each of those are untrue. Now, on the first one, he had insufficient funds and inability to complete the work. So I'm not sure you are saying that's untrue. It seems to me you're probably saying that was true. But the second one, post-dated checks would secure the repayment should the defendant fail. You're saying, as I understand it, that's untrue because the post-dated checks came from closed accounts. So that he always knew that there was no prospect of those checks being honoured. Is that right?
Correct. He knew
Right.
that the checks will never be honoured.
Right. And then the works were being delivered in accordance with the contract, while in truth funds were diverted and checks were drawn on closed accounts. Well, that seems to me to go to the post-dated checks point, which you've identified.
Correct. But Your Honor, he had already taken money first for the whole contract.
Yeah,
and
but
then
just pause a second.
All right.
The rules in relation to fraud are very clear and very specific, and I appreciate that you're a claimant litigant in person, but the rules require that allegations of fraud be clearly and properly particularized. And what that means is that you need to say what the lies are, what the fraud is, what the deceit is. You need to say what is wrong. In other words, you need to say why they're lies, and you need to rely on the facts and matters which support it. Now, in relation to the checks, I now understand your case. You say that post-dated checks would secure repayment should the defendant fail, and I understand you to say he gave these checks and he knew full well that they'd never be honoured because they came from dishonoured accounts. So I understand that allegation. But you haven't set out anything else about what you referred to as the wider fraud in your particulars of claim or in your skeleton argument put last night.
Your Honor, just one part is the contract which we have put in from him, which was there signed by him, in which it is very specifically said that on 7th April, he's taking the money, and by 20th April, he will complete 2022. So that is an affirmation of me paying him the second time for the job to be completed by that time. And he took the money, we paid his vendors, but the job was not done. And again,
sorry, all right, you finish. You finish.
Sorry for this. So for us, that is again for me cheating because he's taking the money second time and not completing with a given written date on that contract. So that contract has been put there with specific dates that he said by 22nd April it will be done. As you know, second time again he came in the end of the year and took money again for the same jobs.
But the difficulty in relation to that is this. You have referred to the contract, and the contract effectively contains a promise that the works will be done by a particular date, and you complain they weren't done by a particular date.
Right.
But and I understand that that this was a 30-day job originally, and it took an awful lot longer than that. But the problem I've got with that in relation to fraud is what's the lie that he told?
He said that he's doing the job, he's taken the money, and he's not put the money into my project and spent it somewhere else. I don't know.
But just pause. Okay, so he does that, but what's the lie?
The lie is he's telling me all in the mail the job is being done. He's telling me that you pay and the job will be done, and we are paying him and he's not doing the job. That's a lie. Because as far as we are concerned, the job should be done.
Right. Well, bearing in mind what I've told you about the requirement for pleading fraud, that's not contained within little d of your skeleton arguments, of your skeleton argument. And if you look at 5, particularization of fraud, you say between April 22 and September 23, the defendant repeatedly represented that he had insufficient funds and credit to procure materials, that he would finish the works within a short time frame if the claimant provided it, and the post-dated checks would secure repayment. But you then say the claimant knew that these false because the defendant admitted having financial strain. Well, where's the lie on that? Because your claim is he said he has insufficient funds, and now you're saying it's false because he said he had financial strain.
Correct. So the lie there is when he said he had financial strain and he wanted me to pay, I paid that money to the contractors, and he gave me a time that in 10 days the job will be done, which is in April 2022.
But but just pausing there, that's in the representation. Okay, so little 2, you're saying that the lie is that he knew he'd never be able to finish the works even if he took the money. Is that what the lie is?
That's right.
Right. Well, you haven't said that in these particularization.
So sorry to say, but we are not professional lawyers. We are simple people.
Well,
and I put in with the best contract which is there in writing.
But Mr. DHAWAN, I do understand this, and I do also understand you're in person. But you've brought this case not in the small claims tribunal, which is designed for litigants in person. You said that although this contract was a small contract, relatively small contract for 150,000 dirhams, you've suffered losses as a result of it, which total, I think, if I'm
5 million.
Yeah. So you've entered into a 150,000 dirham contract, well within it, and you suffered 5 million dirhams of loss as a result of it.
Correct.
Now, if you do that and you put that forward, and even though you're a litigant in person, I'm afraid you have to comply with the rules of the court, because if you don't, your claims are going to get struck out. And at the moment, and I mean, we had this discussion really in May. I gave you the opportunity to replead. You repleaded. I made the order in September. You then came back with a skeleton argument, and I made the observations that I did to which you responded in the skeleton argument. And I know you're a litigant in person, but I've got to be able to understand, and the defendant's got to be able to understand what the lie is, why it's false. And so when you say, well, he knew the representations were false, you need to identify what the representations are and why they're false. Now, at the moment, just coming to your 5 little 2, you're saying, I think you're saying that little 1, he had insufficient funds and credit to procure materials. You're not saying that's false because he was short of money, but the lie is that he would finish the works within a short time frame if the claimant provided specified direct payments to particular vendors. Right. And what you're saying is he must have known that that was false, because he must have known that was false because there was no prospect of him finishing within a short period of time.
Correct.
Right. And the second lie is that you'd be protected by the post-dated checks, and the lie there is that there was no prospect of being protected because the accounts had already been closed.
They never existed, my lord. Yeah.
Sorry, what never existed? The accounts.
the accounts because it was closed in 2018, so it never existed actually when he was issuing the check also.
Yeah, I think we're saying the same thing.
Right.
Yeah, and the accounts had originally existed, but they'd been closed. So at the time that the checks were being put forward, there was no prospect of them being paid.
Right.
Yeah. Okay.
That's right.
Now, so all right. So just to be clear, the lies you're alleging are specific representations, as in 5(2), and post-dated checks on closed bank accounts. And when you say he repeatedly represented that he'd finished the works within a short time frame, what are the occasions upon which he made those representations? When do you say that he said that he would finish the works if you gave him further payments?
So the first time when he said that was on the agreement which I have put in was on 7th of April, which you stamped and signed on an email and the agreement on the same date.
Sorry, 7th of April of which year?
2022.
Yeah.
And then he had told me on 20th April, the job will be finished. It is written on the same piece of a contract.
All right.
And,
okay.
And then he did not do anything. And I had to pay another gas vendor to get the approvals in October of that year. And in September, again, we had to pay another gas supplier after paying the first gas supplier in April to get the permissions. And still he did not complete the job till the opening in May, which was given as a normal, okay, you just open up. EPCO got fed up with us and said you open. And he did not have completed job. In fact, till date, he's not even done a handover to us till date. And we have closed the account on 30th of June 2025 because of so many hassles in that outlet. We have actually closed and handed over the shop back and closed the business.
So it closed what account?
The restaurant which he had done, because it was just running losses because people were not even coming in. There was so much of heat. There was so much of problems. The wash basin has fallen off. This has fallen. Everything was going bonkers. So we did not renew the tenancy after that on 30th of June 2025.
Right. Okay. Now, Mr. Jauhari, sorry, is that how you pronounce your name? I apologize.
RAMZI first name, easier. Yes.
Mr. RAMZI.
Yes.
I'm dealing only with the fraud allegations at the moment. Do you want to comment upon what the claimant has said in relation to the fraud allegation, not as to whether you accept they're true or false, but as to whether or not you understand that the case which is being made in fraud against you is, as I've been discussing with Mr. ATUL?
Yeah, Your Honor. He knows very well that all what he said are all wrong allegations, you know. He knows very well that he never paid me more than what I'm entitled for. He knows very well that the court has given, Dubai court has given the final verdict to return to me the checks. He has now the decision is under execution. He was forced to send me back the check and pay me the remaining money I owe him. Regarding the gas issue he's talking about, it is better to bring the gas guy, the company, to explain to you the problem, why he has made a big issue out of this gas. He was not able to give him a clearance to put gas cylinders. We waited months for him. Then he had a financial problem. He gave me a bounce check. His progress payment, the one we have to spend on the job, it was a bounce check. It took him 4 months to, cover this check. has, so many issues. The time for completion was conditional that he should bring kitchen equipment. He never brought it. It took him more than 1 year to bring kitchen equipment. How to fix electrical and connections and plumbing work if we don't know the kitchen equipment he wants to use? He doesn't know the business, he was hiring and firing. He put first one lady, it was okay, we were going with her fine. Then he fired her. Then at the end, a driver was following the job. His driver was following it. How can you expect, work to be done like this? All his statements regarding money, I borrowed money from him, it's all lies, And the court, Dubai court, proven this. And the verdict was given clearly that he has to pay me back the money I owe him, plus return the checks.
All right. I want to discuss separately the questions of the Dubai court judgment. So at least I understand that, but I want to deal with that separately from the claim which is being made, because at the moment I'm just wanting to understand and be clear as to what the real issues in this case are, and I think understand what it is that Mr. ATUL is saying about fraud. Mr. ATUL, is there anything more you want to say in relation to the fraud matter? Sorry.
The question to me, or?
No, that was to Mr. DHAWAN, to Mr. ATUL.
Yes, Your Honor. The statements which he has made, somehow I cannot even understand, because as a consultant and a contractor to do the job, it was his job to do everything for me, not for me. If I knew how to construct, why would I even hire him? So I think it's totally baseless. And whatever he's claiming, I think we have everything in writing, which we have produced in the court. So I have n number of emails where he has not delivered, and he has given false information, which is tabulated in n number of mails. There'll be more than 1,000 mails sitting in there, which I can give to the court as witness or show it to the court. But the fact is, these are signed documents which he has stamped and signed, which are proving it otherwise than what he's claiming. And the Dubai court thing, whenever you want to discuss, I can talk that also. But right now, what the question you've asked me on fraud is, that's what I have.
Okay. All right. I want to move on, please. And I want to go to the question of loss and damage, which is claimed here. And just give me a minute. Now, you will understand that to allege, as you do, that there is 5 million dirhams of loss, which is suffered as a result of a 150,000 dirham contract, is surprising. Now, in your original skeleton argument, not the one you served last night, but the one which you served last week, you summarize the claim in paragraph 12 as being for 5 million dirhams. Now, first of all, just dealing with the matters we've just been discussing, fraud, and you say cheating and sabotage, 1 million dirhams. Where do I find that 1 million dirhams particularized or identified?
All right. When he has, Your Honor, taken the money from us and not utilized for the project, we have been running losses in terms of the business loss, in terms of the rental loss, and in terms of the opportunity which we created for ourselves.
But just pausing there, you've already claimed misappropriation of advance funds.
Right.
You've claimed double charging and coercion, which I want to come out to. You've claimed forced vendor payments and non-delivery. How can you claim 1 million dirhams on top of that?
So this is a claim we have put on based on what we have lost in terms of business opportunities, sir, totally. And this is all because of him just delaying stuff. We have taken at a very minimal loss number of 2,500 dirhams a day for the losses he created, compared to our neighbor who was doing 5,500 to 7,000, and there was another neighbor doing 17,000 a day there. And this started just after the COVID time. So it was an opportunity when people were ordering, and that is the reason why we went into this business.
Well, just pause. So the 2,500 dirhams a day, where's that?
It's the amount which we have put in for the usage or the daily losses.
Okay, well, that's under your loss of business claim in paragraph 27. The loss is computed
Right.
based on projected daily sales
Right.
of 2,500 dirhams.
Right. Yes, Your Honor.
That's under loss of business. It's not under loss of fraud.
And fraud and cheating, Your Honor, we have put in the money which we have given it to this gentleman n number of times. We've specified the person who he made us pay in 11 in my statement amended claim form which we had put in for fraud and cheating. We took the money and we detailed every place where we paid the money. And for putting us into that situation is the amount which we have taken a few references.
Well, where do I find how the 1 million dirhams is made up?
So because we had paid this money and he's not done the job for us, this is what, after consulting a few people in the business, which is the law business, they told us to put it for the judge to decide finally. And that is why in the end argument, we have written that your final decision is most applicable. Because we don't know
there's a problem about this. And it's a problem which you've been aware of since May. You can't just pluck figures out of the air. You can't say, I had a 150,000 dirham contract for 1 month, and I then suffered 1 million dirhams of loss. And you say, well, ask the judge to decide. I mean, this is something. How do you make up the 1 million dirhams? Where do I find the calculation?
For somebody taking the money from me, making me pay 3 times and not delivering, he should be accountable for some amount of money and the losses he's created.
Okay, so there isn't any calculation at all of the 1 million dirhams, is that right?
For the cheating and fraud, for the delay, yes, that's the number we have put in, yes.
But there isn't any there isn't any calculation of it. It's a number just plucked out of the air.
Your Honor, you may be right, because we are not professionals. What we were advised by the law firms is how we put that.
Well, you haven't got a law firm here. If they had, I'd be saying to them very clearly, where is this coming from? And as far as I can see, it is literally a number plucked out of the air. Is that fair?
Not really, because yes, we do not have a law firm, you're right, because we cannot afford one at this stage. And we have taken this time after running around talking to him for so much of time, 3 years, and still he didn't hand over. That's the reason why we went to the court. Otherwise, we wouldn't even have gone to the court. He never came onto the table to hand over. So when we consulted a few people, we paid a little money and they gave us this kind of advice, and that's how we've gone in with this.
Right. Okay. Now, going back to the claims, the misappropriation of advance funds, 95,000 dirhams. Where do I find a list of those advance funds which were paid? Where do I find how you get to 95,000 dirhams?
So that is in a statement of the money which we have paid to him for the 25% advance, 25% in the first 7 days, and 25% later. But it was based on his stages of completing a certain work. And based on that, within the first year, we have paid that already to him because he was delaying everything. And when he was getting things on site, we were paying him, and he has been paid based on that.
Okay. Now then, substandard and wrong materials. Where do I find the 100,000 dirhams which are made up?
So
how's the 100,000? Sorry, let me rephrase that. How's the 100,000 dirhams made up?
So the material which he had to put on ground as per what the agreed thing was, he did not put. Like he made me pay for the AC machine. He made me pay again for the material. The material which he's put in is wrong material, so we had to change that material and put it on our own because he never even came to the site after that. So all those materials have been changed, and we have shown some pictures in the court what the defective bad pieces were. We can see the door of the bathroom. A woman could not even enter a bathroom in a restaurant because you see the picture which is there in the there. It was totally broken, and he didn't do anything from day one.
All right. Now
So
then you get double charging and coercion.
right.
So this is another 500,000 dirhams. What's you've already claimed back all of the advance funds. You claimed 100,000 dirhams for substandard and wrong materials. Where's the 500,000? What's that? Did you pay that, or what is it?
Correct. So no, that's not paid, but every time he got me to do any job which he had to do after taking the money, he would threaten me to say, if you don't do this, I will not do this. If you don't do this, I will not do it. Whereas the contract was very clear that he had taken the money to do end-to-end delivery. I didn't have to get involved. He was a contractor, and he would threaten me every day for something or other, to the extent, Your Honor, the gentleman did not even know that in a kitchen he had to put a fire retardant steel material, which he put a wrong material. And now people came and put everything down, and he made me pay for that. He said, you gave me wrong. As a contractor, he's supposed to know that. I don't know that. He was given the guidelines by ANOC directly. The engineering team gave him, they were put together right from beginning, and they were given the thing. Still, he put, and he was trying to get the stainless steel passed when you need a fire retardant system in all your kitchen. And he didn't even do that. Every place he's gone, we have so many mails, everything which he's put wrong. And then he says, this is not specified, this is not done this is not done this way. Everything went wrong. And that is the threatening he would do every time. Okay, to move ahead. Okay, you want me to do this? Then I will move ahead, otherwise I'll not move ahead. And that is what he was doing. And eventually we realized that he was not even paying, and I had to pay again double at the end to get my job done.
Right. So my question is, how does this 500,000, how's it made up? What elements of money are comprised within the 500,000?
The elements of money is his threatening, pressurizing, and getting us to do the job is made us do this.
But what is the 500,000 dirhams?
For my team to go and do the job rather than his team to go and do the job.
Right. So who's your team?
my staff, and we had other people. We got the job done. We got other contractors to do.
But that's claimed already within the substandard and raw materials. You've claimed money for other people to do the job there.
As I said, this money is basically for the pressure and the threats which he put us. We have put that on him because he threatened us that time for everything.
So it's not a monetary amount, it's a compensation.
Agreed. I agree there. Yes, that's what it has been put on us. Yes.
Okay, all right. Now then we get forced vendor payments and non-delivery, and this is 780,000 dirhams. Well, again, why is this not comprised within the 95,000 and the 100,000?
So the vendor payments include even the rental which we are paying, even we getting jobs done from outside, our staff who's going to get the job done, their salaries, everything we put that like that.
Well, where do I find a calculation of the 780,000 dirhams?
We have not put in there. We put that based on the calculation which we did internally.
So there are no details of this?
Except his vendor payments, which we have put in, the vendors which he asked us to pay, we have put that further down, and you've seen that.
Just to be clear, what vendor payments are we referring to?
Where he made us pay to all these guys, the Javed, for the FACUH machine, to pay to the camera people.
Are those? Is that the loss at paragraph 11, where you say Bushara Jabal Ali 5,000 and then 2,000, and then
yes.
Well, that totals, I think, something under 50,000 dirhams.
Around 45, 46,000. Plus we paid for the internal system.
Right. So that's all the details which goes to the 780.
Correct.
We've discussed the frauds, cheating and sabotage, and we've dealt with that already. And then we get to the loss of business and opportunity. Now, I want to just understand this quite clearly, and I think you deal with this at paragraph 9 of your skeleton argument. Now, what you're saying, as I understand it, is that entirely because of the defendant failing in respect of a 150,000 dirham contract, you didn't start operations until May of 2023.
Correct.
And when do you say they should have been started?
It should have been started in March of 2020 latest.
Right. So March of 2020. So right in the middle of COVID.
21. Sorry, 20. We paid him the money in December. So 20. Yeah. March 2020.
2020 or 2021?
So we paid him the money in 2019 December for 30 days.
Right. So just to be clear, you're saying that March 2020, your restaurant didn't open, even though March 2020 is, as I was saying, right bang COVID.
Correct.
Well, is it true that you'd have opened a restaurant in March of 2020 in COVID, but for the problems on this contract?
Could you repeat that, Your Honor?
Well, I'm looking at the reality of this, Mr. DHAWAN. March 2020 is when COVID hits the world.
Right.
Gets to Dubai a little bit later than some other places. But you're claiming, as I understand it, against this defendant, that as a result of his failures, you're entitled to 2,500 dirhams a day, starting in March 2020. That means that you're saying, if it hadn't been for his fault, my restaurant would have opened right when COVID occurred. And I'm saying that looks rather unlikely, doesn't it? Because of COVID.
Thank you for pointing this out, Your Honor. But if you know, in COVID, all food people made the maximum money because we were doing online deliveries. We as a company were allowed to go and distribute on our own, and that the government had given us permission, and only restaurants were making money at that time. Everybody.
Okay, so it didn't matter that your premises were closed because you were able to make deliveries. That's what you're telling me.
We could have if the kitchen was working. We didn't even have a kitchen running.
Okay. So what
So
your
kitchen
case
was not
is,
made.
so your case is that you'd have been able to make online deliveries in March of 2020, but didn't do so.
Yeah, we would have started then and gone through the whole of COVID till 21, 22 were doing very well. Everybody was doing very well in terms of the business.
So you didn't do any business in that time, is that right?
We were just running to get the job done from them.
So you didn't make any deliveries, Mr. JAOUHARI, is that what you're saying?
100%.
So you did no business at all?
Yes, Your Honor.
Yes, you did, or yes, you didn't?
We didn't.
Right.
We didn't.
Okay. So you're claiming 2,500 dirhams a day. What's the start date for that?
We would take it from March maximum. I would give him 1 or 2 months extra. If from December I've paid him the money, that's I said 3 months I gave him, and that's how we started. But
So
in our calculation, we started from 1st of June.
Right. So the 1st of June is when you say you start the calculation.
Yes. And Your Honor, in this much time, he had not even got the drawings approved.
Can you just remind me where the original contract is, please?
Contract B financial. So in section B1, I think it's opening up.
Oh, yes, thank you. Let me just have a quick look at
Yes,
that.
section B1, sir.
Let me just have a quick look at that. Thank you.
Oh, it's 20 and 20, sorry, 20 and 21. I've also got now run down with the dates. My
That's
fault.
right. That's right.
It's so old that I don't want to think about it. Your Honor, with your permission, can I have a glass of water?
Yes, I can't give it to you, but
No,
you can.
Thank you.
You can certainly, as long as you're going to get it yourself, you can.
Thank you.
Yeah, I'm sorry, I don't understand this. You told me that the calculation starts from the 1st of June of 2020.
21. I made that mistake. My apologies. I just said that because it's too long a thing. The contract was signed in December 2020 and 21 June is what we've taken that out.
So
My apologies for that. Yes.
Sorry, so it starts on the 1st of June of 2021.
Yeah, because ASHOK started billing us for the rental from that day. That's why I take it from that day.
Okay.
Before the 6 months, they gave me the leverage because we fought and we agreed with them and we told them we will do it on time, and
Okay,
they gave us that leverage.
I'm just trying to get the calculation. And when does it finish?
In 23 May, we just started, but the handover was still not done. because there were a lot of things which are still not completed, and he did not do it, and I had to get people from outside to do it. Safety standards were not taken into account, which when they gave us the initial approval to start work, they told us to get those things done also, including the alarm systems and all, which are not in place. And we had to pay that contractor again because the defendant didn't come to even get that job done.
Now, so you're saying 2,500 dirhams a day and 2 years at 2,500 dirhams a day, i.e. from June 2021 to May 2023 comes to 1.825 million dirhams. How do you get to how do you get to the how do you get to the 5 million?
So, Your Honor, this is the cost for the business loss at a lower level. Plus, we have put the rental, which we have lost.
But I don't understand this.
So Your Honor, apart from the money which we paid him, we lost on rental because we were not operating for till this time, and we are paying a rent of 150,000 dirhams a year to ANOC every year as rental.
Sorry, let me be clear about this. You've claimed, as I understand it, 2,500 dirhams as being your gross takings per day, every day, 365 days a year for 2 years.
Correct.
Well, out of that, you'd always had to pay rent.
Rent we were paying separately.
Well, I know, but if the business had been running, you'd have had to afford the rent from that money.
Yes, if the money would have been coming, I would have paid from that money. Yes, agreed.
So it's not an extra cost.
So I agree with you to a certain extent, but that money I did not earn, and I had to pay 450,000 from my pocket. So had I earned that, I would never have paid money because from the profits, the money would have gone in there. But
Yeah,
right
well,
now,
I mean, I understand that what you're saying is that your gross takings would have been 2,500 a day. It would have been for a 2-year period, which, as I say, comes to 1.825 million. But the point I'm making is that from that, you'd have then had to pay, well, for everything, for food, for your staff, all the other costs of running a business. But you'd also have had to pay the rent out of that. And
100%. I agree with you there. Yes.
Yeah. So your claim is based on a gross takings basis. I mean, it seems to me the most that you can claim is what your lost profits would have been. In other words, that amount less the savings that you would have made. Is that right?
Your Honor, you might be right in those calculations and audit numbers, but the fact is, because I did not make the money, I had to put in another 450,000 from my pocket to pay the rent.
No, I understand that, but that seems to me to be double counting. Anyway, now the second thing is this. This is a 30-day contract. It goes wrong. Why didn't you get someone else to do the work rather than carry on with the defendant over this 2-year period when your restaurant wasn't able to open?
Correct. The point is, he had taken advance. If you see the contract, he'd already taken the money. Now, again, to go to somebody else and get them and get the whole process started would have created more problems for me with ANOC, because ANOC, you have to get the vendor and the contractor aligned with them, and they give the information, and that's how work starts. That's the process. So this gentleman had already gone through all that process and done the agreement with them, through us. So to get another person would have been a bigger challenge. Plus, he had already taken the money from me. Now, how would I get the money back from him? That was the question.
Okay. All right. Now, Mr. RAMZI,
Yes.
looking at the loss which is claimed against you and identifying the sums which are claimed and which come to the 5 million dirhams, it seems to me that it's accepted that the double charging money and the making his pay 700,000 and the fraud and cheating are all additional sums which should be payable. And at the moment, it seems to me that there's no proper basis for them. It seems to me that you have got lists of the money which is said to be the misappropriation of advance funds and the substandard and wrong materials, and the loss of business claim seems to me to be on a gross takings basis with the based on 2 years at 2,500 dirhams a day, which gets to 1.825, and doesn't take account of any savings which would have been made by the business. Not that seems to be the case which is being put forward in relation to this. Now, do you have any comments in relation to that?
Yes, Your Honor. He keeps saying he paid me 3 times. It's very simple. Let him produce documents, prove that he paid me 3 times. It's very simple. If he overpaid me, let him prove it. Let him bring papers, documents, transfers to my bank account, a check given to me that he paid me 3 times. Again, Your Honor, if he's not happy with my work, why he would be inviting me in August 2023 to do another job for him in Jabal Ali? All his allegations are made up stories, you know. There is nothing like this at all. I don't know why why would he claim 5 million dirham in a job of 150,000 dirham? As per FIDIC contract or whatever, there is nothing like this. He opened the place. He operated for 2 years. He was making deliveries. It was wrong that he was not making delivery. He has an outside kitchen. He was making deliveries all the time. All what he's saying is, I don't know what to say. I'm not, I don't want to say an impolite word, but he's wrong allegation. Everything is wrong. He's talking about safety standard. He has approval from civil defense, from all authorities, approval to open the kitchen, the restaurant. Please ask him, please, Your Honor, ask him to produce the invoices for his kitchen equipment. When did he buy his kitchen equipment? He never bought the kitchen equipment until very late, after maybe one year after signing the contract. Plus, again, payment problem. He was not paying on time. He gave me a check. It bounced from the bank. How can I go and do the work if his checks are bounced? He told me that he was, having a financial issues and his accounts are closed in the bank, and he had to sell one property to cover to pay me. That is his words. But why would he invite me for a job in Jabal Ali in August 2023 to do another job for him? I have every proof. I have an email. I have shared the mail with the court. I rejected to do the job for him because working with him is nothing but trouble. again, handing over was related to so many issues. He said that he opened without approval. He cannot open without approval. He cannot open without civil defense approval. He cannot open without authorities approval, without DEWA approval. We brought everything to him and then he opened.
Okay. Anything else you want to say on this subject, Mr. Ramzi?
You see, I have shared with the court every single document. Plus, again, I'm saying if he overpaid me or he paid me 3 times, let him produce papers. How can we depend on what he's saying? I paid him 3 times. Fraud business or lying business. I have proved to him and to the court that the Dubai court has appointed a specialist, an expert. He went through the account and he has given his report that we still need money from him. And the court final, verdict, it was also the same thing, to return the checks to me and to pay me the money that I owe him.
All right. Thank you. Mr. ATUL, do you want to say anything in response to that? In response to what is said, I mean, the fact that you invited him to do a job at Jabal Ali in August of 2023, do you accept that?
No, Your Honor, the mail has gone. It's correct. The team which is there, they have a list of vendors. The automated mail which goes as a basic to 20 vendors has gone for the job. It's gone to him. I will not deny that. And the fact is, it never was taken to the next step. Ask him, did he ever come to the site? Was he ever called to the site? The moment I saw that mail, I told my new member, because that lady who was dealing before, she had made a database list from which the mail has gone as an email inquiry. And that was about it. That's the first thing. Number two, he is asking the question whether he's made 3 times payment to prove. Those documents are already in the court, where first I made all the payments which I checked, which he's accepted that he's got it. And the second and the third, which we are claiming, is on the agreement which I've paid his vendors 2 times. So that's the 3 which we are talking about. So what proof else apart from that, I need to show that it has to be done. And Your Honor, one last thing which I want to ask you, the help part. We had an agreement of going to DIFC court and we came here.
Oh, just pausing there. Where is the agreement about coming to the DIFC court? Where do we find that?
So the claimant, the agreement sheet which we have signed, in which the date is written of 7th of April. I'm just trying to pull that document out. In the agreement. Yes, sir. There is B9. If you see, there's an email also in the contract also.
Let me just have a look at that.
That's an email.
And it's a contract also.
Just pause. Just pause. Right. So on the 9th of April of 2022.
Correct.
Yeah, okay.
So I have highlighted, Your Honor, with green all the points which are relevant in terms of date, delivery time, DIFC code. And it's on the contract, on the email, and his handwritten notes also, which are there in the system.
Okay.
So 3
Right.
documents.
No, but the main, sorry.
No. I'm going to ask you.
The main
contract.
contract.
Just wait a second, Mr. Ramzi. Have you finished in relation to that point, Mr. ATUL?
So the allegation, and in this sheet also, if you can see the payments which he's talking about 3 times, twice I mentioned on this, and what was all before 95,000 which I paid. So that's what we are referring to 3 times, which is wanting us to repeat again and again. And just for the Dubai court thing, those hearings was not supposed to happen. We have put the objections every time there. Thrice it was rejected there for jurisdiction. And then the last thing, he's again gone behind, and we are not even attending or trying to attend just because the hearing is there, which he has confessed and agreed with you in May in the last hearing that this is the agreed jurisdiction. So, Your Honor, my request is that we need some kind of direction for that judgment and thing to be put aside, or I don't know how we do it, but how can the same case be held in 2 courts? I've not heard this.
Well, okay. Now, the Mr. Ramzi.
Yes.
What do you say in respect of what Mr. ATUL has just said?
Mr. ATUL himself, went to Dubai court to try to encash our checks. He went to Dubai court. He presented the check to Dubai police, and he went to the court to encash the check. So he started this, not us. Then, okay, the main contract agreement has no conditions at all. The main contract, if you see the main contract, so automatically things goes to Dubai court. It's as per rules and regulations, If no mentioning about the court, we should go to Dubai court. In fact, after he went to the court to encash our check, we had to defend ourselves. We went to civil court. We accepted the police judgment, and then we went to the court to finish the procedure. And Dubai court has given us the right to get back our checks. In the meantime, to pay us our balance amount.
So, and in relation to the proceedings before the Dubai court, Mr. Ramzi, are you saying that Mr. ATUL did or did not participate in those proceedings?
He did, of course, and the expert met with him, and he gave him all statements, and of course he was, together with us in every step of even he appealed. Even after the first verdict, he went and appealed the judgment, and also he lost because of time. He did not give his appeal on time. He was late. He was late on payment again. He did not pay the court.
So, Mr. ATUL, I'm going to hear from you in a minute. The way this works is one party goes, then the other. I want to hear what Mr. Ramzi has to say. Don't worry, I'll come to you in a minute. But at the moment, I want to discuss this with Mr. Ramzi. Now, in the email which I sent, or caused to be sent last week, you were taking a point as to jurisdiction of this court, and I was making the point, well, you haven't protested jurisdiction. But there is a separate ground, which is that if another court has already decided a dispute, then there's no room for that dispute to be decided but by another court. It's called the principle of res judicata. Do you say that the Dubai court has already decided all of the issues relating to this dispute as between yourself and Mr. at all?
Yes, Your Honor, it's all done. Final verdict is given, and it is the verdict is under execution now. He has to, follow the verdict decision, the court decision.
Okay, all right. Well, I understand.
It's being executed.
Okay, well, I understand your position. Now, Mr. ATUL, first of all, did you participate in the Dubai court proceedings?
No,
So what do you say happened?
Your Honor, now I need to tell you a little thing. What the defendant is trying to do is, as usual, always confuse things. So there are two cases in Dubai court. First, we went to the court, which is not a Dubai court hearing. It was a bounce check, which anybody has a bounce check has to go to police. Even if it is from DIFC, you have to go to Dubai
so
police.
you went to the Dubai police and you made effectively a criminal complaint.
Correct. And that case, we won all through with the public prosecutor punishing him. And that was the end of the story.
Yeah.
And
Okay.
while we were doing that, we had lodged a case in the DIFC court.
Right. This case.
This case,
Yeah.
which Mr. RAMZI never came for the first hearing, and it was awarded without his coming to us, which he appealed. The first decision was 5 million is awarded to us, which we knew would be appealed later. And then this proceeding is happening. What Mr. RAMZI did after that, went and to the Dubai court and put a case against us for this case, which we are doing here in the DIFC court. First thing, we didn't attend, and it was because we had to put in a note, the jurisdiction was ruled out and he lost that situation. We just said, this is not your jurisdiction. We didn't participate really. We said, if you're already in Dubai court, we gave the judgment of the first decision and we said, this is DIFC jurisdiction. The case was dismissed. He appealed again on that. It was again dismissed. Those documents are already put into the case bundle. Then Mr. RAMZI has gone again and went. And in that time, sir, we sat for the hearing, which is electronic. Like today, I got a problem of entering. I got in at the very last minute, and I'm not on my laptop. It's on another laptop, which has been given to me. We could not even attend the hearing. We went to Dubai court the same day, and we said we were not allowed to enter the hearing because we would have said the same thing, that this is not the jurisdiction, and the two verdicts. They said now nothing can be happening. You have to attend the next one and do that. We went for the next hearing. The judge, it was delayed by my lawyer because we were not even interested because of the judgment issue. There was a holiday in Dubai on that day, so they put the thing of that the jurisdiction is DIFC the next day. The judge did not see this because he said you were supposed to do one day before. Without taking our note that this is not the jurisdiction, he gave a judgment in which, Your Honor, because of the calculation which Mr. RAMZI has done, I have to pay him 7,000 dirhams. And 10,000 dirhams is the court fee. So the judgment which has come against which he is talking about execution is only 7,000 to Mr. RAMZI as per his calculation and 10,000 to the court fee. Now, why is Mr. RAMZI not saying all this to you right now? Because he's just saying, I've got the judgment. And for that, we have asked your court to say that that judgment should be put aside because we are already in this court and we have not been contesting, and twice we have got the verdict that that is not the jurisdiction. So why am I contesting in two places was the reason why we've not done much. Right. And that's the explanation of the two cases there.
And have you sought to set aside the judgment of the Dubai courts in relation to the 7,000 dirhams?
So we have applied for the execution to stop. That's
right.
The only thing
that's not the same. Have you applied to the Dubai court to set aside the 7,000 dirhams?
Sir, as you rightly said, you cannot put that. You can only stop the execution by saying that we are already in the DIFC court. That is what we have been doing.
Sorry, I haven't said anything. Well, I simply asked you, have you have you applied to set it aside? And I think the answer is no, is it?
No, because we still have time for this judgment. I was waiting in our skeleton argument here. We've asked you for that so that we can take this note and give it to that court. We still have time for that.
I don't have power to set aside a judgment of the Dubai courts. You have to do that. Now, it may be that I could or could not give relief in this court, but the setting aside of the Dubai court's decision is not something which I can do. That's a question of ensuring that there is jurisdiction and dealing with it. All right. Well, I understand what you say, Mr. Ramzi. Do you want to say anything in relation to that?
Yes, Your Honor, he was involved very much on this court. And to your information, his statement to Dubai court, he claimed that he had a final decision from the IFC court, and he attached the default judgment, which was overruled afterwards. So he was also lying to Dubai court. And also he did not apply, he cannot do anything anymore because the final verdict is given, and he tried to execute the check. Again, after the court decision, he went to the court and tried to execute the check, which the court told him to return to us. He was also playing on this, plus the check, the 4,000 security deposit check given to him, he played with the date. He changed the date of the check, so the check never came to my bank. The check was returned from his bank because the date was played with. This is another case I'm filing against him for fraud. He will receive shortly the notification. He tampered with the date of the check. And he did everything. He did everything he could do.
Right. Well, and who you're proposing to file this case? Where are you proposing to file that case?
You're asking me, Your Honor?
Yes, I am. You said you were going to file a new case. Where are you going to file that?
In the police. First in the police.
I see. All right. Now, all of this comes as a result of a case management hearing which took place in May. And it will be apparent that it seems to me that this case has got, frankly, completely out of hand on both sides. As I see it at the moment, in relation to the claimant's case, the sums which are claimed in relation to the, in the amended claim form, which are identified and which come to 5 million dirhams, I'm satisfied that there is no proper basis at all for the claims in respect of 1 million dirhams for fraud and cheating, 780,000 dirhams for making us pay the vendors, 500,000 dirhams for double charging monies. So far as the other sums are concerned, it seems to me that there are claims in respect of particular items, and I understand at least the basis of the claim, not for, I think, 2 million dirhams, but for 1.825 million dirhams in relation to the loss of business, it essentially being alleged that the restaurant was delayed by 2 years. I also understand what the claimant is actually saying in relation to the fraud and cheating And it seems to me that the claimant's case in relation to the fraud and cheating is twofold. First, that the claimant was induced to make payments as a result of statements which he's going to have to identify particularly, to the effect that if payments were made, the works would be finished. And secondly, by the production of checks from closed accounts, which were said to be security for non-performance of business. Now, that then leaves the question of the defendant's position. So far as the defendant's position is concerned, I understand that he denies all of the points put forward, but I think he also has a case that the Dubai courts have dealt with the substance of the dispute between the parties, and that there is a final judgment which should be taken account of. Mr. ATUL's case in response to that is that the Dubai court judgment shouldn't have been given. I think it may also be that the Dubai court judgment did not deal properly and fully with the entirety of the dispute between the parties. Now, I have to say, both of you gentlemen, it seems to me that you are, if I may say so, spending an awful lot of time and money. And I frankly regard the 5 million dirhams being put forward as being numbers plucked out of the air for 150,000 contract. I understand how you could possibly get to 2 million dirhams, but just standing back from this, if you were to say to an outsider who've got 150,000 dirham contract and I'm claiming 5 million dirhams for the response to it, most people would say, well, don't be ridiculous. How could that possibly be? Equally, Mr. RAMZI, it seems to me that from your point of view, you're making quite a few allegations in relation to it. It does seem to me, from what I can see, and I'm not making any judgments here, that the production, for example, of checks from accounts which have been closed does not seem entirely sensible. And you are running off to lawyers in two different jurisdictions. You're incurring time and money, and I can't help thinking that you would be better off, frankly, seeking to settle this. But if you don't do that, this is going to have to go to a trial. And if this goes to a trial, you're going to have to spend more time and money in relation to it. And you're also going to have to set out your case clearly, which is what I've been trying to get you to do up to now. Both of you are going to have to set out your case clearly. And frankly, I told you to do that in May. You didn't do it. I told you to do it again. And although it is getting better, it seems to me that it is still far from perfect. And this is actually the case on both sides. But I want also now to discuss what happens if this does go forward. Because the first thing that's going to happen is what documents each of you are going to produce. Now, first of all, you each in a position to produce the documents upon which you rely in a relatively short time frame? And I'll ask Mr. ATUL first.
So, Your Honor, just give me 1 second. I need the cable to go. I'll set in. My battery is just running out on this other laptop. Can you just connect? Sorry, yes, Your Honor. Could I get the question again? I didn't hear you.
Are you in a position to produce the documents upon which you rely in a relatively short period?
100% I am.
Right. How long do you need to produce your documents?
Your Honor, they're already in the case bundle. I just have to pull it out and hand it over and add more emails to some of the counters which he's putting up right now. One, I actually wanted to show you on the case bundle right now. It is there. I just want to give you the number of that. If you just give me a minute, I'll get my other laptop in a second. I'll just run and get it.
Sorry, what are you wanting to show me?
I want you to see one claim which he's claiming on the check. I just want to show you. It's in the case bundle already. I just want to give you, get my laptop and tell you the number. Just 1 second. Sorry about that, Your Honor. I'm back. Your Honor, in my case bundle C.3, if you can just open that for 1 second.
Yeah.
In that, the check which he has issued, if you see on 9/4, he has written himself balance of the AC work on that check which he's issued to me. Total amount this much paid by Mr. Atul, 10,000 after completion. And in the court, he's claiming something else. Now you go to the second check. Again, he's written difference of the gas installation of 14,000. He himself, that's his handwriting, and he's signed next to it.
Your Honor.
Just let
Sorry,
me say what I have to say.
one at a time. I'm not sure this is helping me, Mr. Attle, but what's your point?
My point is he just made the statement that he gave me post-date checks, which were guarantee checks and not to be encashed, but see what he's writing there. And
Your Honor.
I have not even changed dates. If you see, he made checks because he did not have money. 2 checks he made at for the month of May, and his man went to the other room, got it, came back, took the signatures from me first, and then changed it to 6. He said, can I do it 1 month later? And he changed the date, which I told the public prosecutor also, and they accepted it. And after that, they gave him the punishment on the check. So he cannot do anything on the checks. He's giving wrong statements.
Right. Well, I don't think that's helping me at the moment. But
right.
As as you've made those statements, Mr. Ramzi, do you want to say anything in relation to that?
Again, the check has been changed, by him. The 2 checks I gave him from Dubai Islamic Bank. When I went to Dubai Islamic Bank, they have no record at all of receiving those checks. The checks, he made it return by his bank. It did not go to my bank because of date change. It's very, very simple. When you receive a check, how can you, he received the check. How can he again, how can I take it again from him, take it to another room and change the date and bring it back to him? How could it be possible,
All right. Look, I'm not
all deposit check.
I'm not being helped by this.
Your Honor, if you just, somebody looks at the expert report, and the expert report, he has all this information there. I have translated to English and shared with the court also. He has made reference, and all details are in his report. This report was given to the Dubai court.
Correct.
That decision is in our favor for the checks.
Well, look, gentlemen. All right. So you can give all the documents you need within what period of time? Within 28 days from today, Mr. Attle?
Yes, Your Honor, I can do that.
Right. Mr. Ramzi, the documents you want to give, can you give all the documents you want in relation to this dispute within 28 days?
Yeah, no problem at all.
Okay. Now, do you gentlemen understood what is meant by alternative dispute resolution?
Not really, but I'll find out the best way I can.
It's contained in Part 27 of the DIFC rules, and it's designed to assist in a settlement of a case. And it'll already have been apparent to both of you that I think there are difficulties in relation to both of your cases, and it seems to me that you really ought to be trying to resolve this dispute and move forward. As I say, the court will decide this matter if necessary, and it'll need to go into all of the issues we've been discussing today. But the overall view that I'm getting is that, if I can put it this way, both of you gentlemen are likely to have better things to do than spend time and money going over the events of, well, up to four years ago. Now, in Part 27, the suggestion is that you look for neutral individuals to help you resolve it, and there are people who can be approached. The order suggests that you exchange 3 neutral individuals who are available or you would think would be able to help you resolve the dispute, and then you seek to choose one. If you can't choose one, the court will assist you in relation to that, and those individuals are likely to use a colloquialism, try and bang your heads together so that you achieve a resolution. Now, the court's view is that that would be a very sensible order to make in this case. I'll ask for your views in relation to it, and I'll ask them in turn, Mr. ATUL first, and then I'll ask you, Mr. RAMZI.
Your Honor, I'm happy to hear this, and I think it's a good point to work with. It might be faster to come to some conclusion. But my question is, are these people lawyers, or who are the people who are the
some of them are lawyers, some of them aren't lawyers, and you can put people on the list who are or not lawyers in terms of whether or not you think it'd be a good idea to have a lawyer or a non-lawyer in relation to it.
But 2 questions there are. One is, we'll have to pay them to be mediators.
They're not going to act for free, no.
Correct. Second thing is, with the defendant, we've not even been agreed to come on a date together. How will you come to 3 people together? I think he'll never agree.
Right.
That's my problem.
Let's see, Mr. RAMZI, what do you say about this?
See, Your Honor, he opened the case against me. I don't have anything against him except to pay me my money only. Otherwise, he opened the case, and he's claiming on 150,000 dirham contract, 5 million dirham. So the issue with him, not with me.
All right. Well, but I'm asking you in relation to the prospect of.
I'm ready for any. Yes, I'm ready for any amicable solution.
The court is going to make an order in relation to the court is going to make an order in relation to alternative dispute resolution. Now, on documents, on documents, do either of you consider that you're going to need to ask the other side for documents relating to the resolution of this dispute?
Your Honor, I don't think so. I need any documents from him because all are on email and we have copies. He will have his copies, I'll have my copies. So we have our documents with us. At least I have my documents with me.
Right. Mr. RAMZI, do you think...
I have all documents, no issue.
All right. So you're... neither of you think that you're going to need to have documents from the other side?
Not at all, Your Honor. I don't need them.
No.
Right. Now, in relation to witnesses, are you each in a position to identify any factual witnesses that you think would be required to resolve this dispute? Presumably each of you 2 gentlemen is going to be giving evidence, but do you have any other witnesses that are going to be involved?
Yes, from me I have, yes.
Sorry, yes, is Mr. RAMZI, is that yes or no?
Yes.
Yes, there will be other people.
There will be witnesses, yes.
How many?
Okay. Do I have a limited number or any number of people? I have so many.
Well, the answer is there isn't a limited number of witnesses, although the court is unlikely to be assisted by people who don't know what's happening. But the reason I'm asking is I'm trying to get a view as to how long this trial is going to take if it goes forward.
I can have up to five witnesses, maybe.
That's including yourself, I assume.
Yes, that's no problem.
Okay, Mr. ATUL, what about you?
Your Honor, I would need a little more specification. These witnesses he's talking is about his own staff, and for me also my own staff or outsiders?
No, I'm well either, but I mean, I suspect Mr. Ramsey may well be referring to his own staff, but I didn't actually ask him. But at the moment, I'm asking how many witnesses, whether they're your own staff or outsiders, are you likely to be calling?
So, so for me, I think I'll use only one staff, maximum two from my internal staff, and the other person whom, if they come, I think the court will have, can the court issue an order, because the contractors who supplied the stuff, if I tell them to come, most of them will not come. Most companies don't allow the people to go out. But can the court ask them to come because they were the right people? They've given a letter in writing, but I don't know whether they'll come in front.
I'm not going to give you advice about getting other people to come. At the moment, I'm just trying to get a list. You're saying at the moment, I think that there might be 3 witnesses, and you might want to compel some other witnesses to come forward.
Suppliers who did the job and who will tell you how wrong it was done or not wrong, whatever it was.
Okay. All right. Well, I'm getting a view, at least in relation to this. Now, what about experts? Are you going to need expert evidence to have this resolved?
For me, the contractors are the experts. The people who install the material are the experts. So there are no additional experts. The contractors would be the people.
So you're not seeking to call expert evidence. Mr. Ramsey, what about you?
Yes, let the expert come. He will know better.
Well, are you saying that you would want experts to come or not?
Yes, of course. How would we know who's right and who's wrong without an expert?
Right.
Without somebody looking at the contract and checking.
What sort of expert are you looking for?
Contractual expert, somebody looks at the contract and see what we have in our scope and what we don't have in our scope.
When you say a contractual expert, are you referring to an engineer? What sort of person are you talking about? An architect?
Yeah, who should be an engineer, of course, or architect, both of them engineers. They know about the building thing.
So
yes. Excuse me?
I didn't hear what you said. Sorry, Mr. Ramsey, I didn't hear what you said.
Yeah, I'm saying that he should, somebody who is able to check the contract, check what is in our scope and what is in the client's scope, what we had to supply. An expert is the only one who knows, and he should go as per FIDIC contract. There is an international contract, FIDIC contract. It has a definition for everything.
Well,
because it's not like
this
talking and talking.
This isn't a FIDIC contract, but I mean, you could easily call, or someone could come along and give their opinion as to whether the quality of works that you did was or was not sufficient, or whether or not it was within the scope.
But who will determine, Your Honor, what is in our scope and what is in his scope? Who will make sure that what he's saying is right? Well,
ultimately that's going to be for the court to decide, but it may well be helped by an opinion from an expert.
If he agrees on putting somebody, expert, and he will, go with his decision, I have no objection. I'm open,
All right. Okay. Mr. ATUL, you wanted to say something?
Your Honor, the point of putting an expert to ascertain the quality of material would not be a viable thing now, as the project has already been returned back to the main company and it's been destroyed and somebody else would have come and taken over. So I now have no material proof to show what quality of work was done there except the pictures which has already been submitted. So that kind of expert is not feasible, I personally feel. Okay. But yes, the contract, what was written is very clearly written, a key-to-key contract and all, which is any person who's seeing a proper contract can understand what is a key-to-key contract compared to what I'm supposed to do and when I was supposed to do, which he's claimed when the kitchen equipment was given, why it was delayed. He knows it because we have it on writing in email. When do we get and WhatsApp messages the kitchen equipment? He says, I'm not ready. When I'm ready, only then you can get the equipment. How will I have the equipment? And I can show you when it was ready and sitting in my warehouse for 1 year.
Your point is that you don't think that an expert is required. Mr. Ramsey's point is that he thinks an expert is required. That seems to me to be the position.
I'm fine if you think there's somebody who can go to a place which is not existing. What does he do?
No, I'm not talking about contractual man, contractual engineer who can define what is in my scope and what is in his scope and why the job was delayed.
Gentlemen. I understand the dispute of the between you. Right, I'm going to tell you now what the court is going to do. I'm going to tell it you orally, but the court is going to issue directions together with brief reasons afterwards. So you'll have a written record of what happens, but I'm going to tell you what the court is going to do so that you can each hear it from me orally. Now, it seems to me that the starting point in this dispute is what the claimant is actually claiming. And it seems to me that we have got some way towards understanding that. I am satisfied, and this will be set out in the judgment, that the sums which are claimed for 1 million dirhams for the 1 million dirhams for the fraud and cheating. Just get the documents. That is simply a sum which is, to use the words, plucked out of the air, and there's no additional basis for it. I'm also satisfied that the 780,000 and the 500,000 fall into the same category. That then leaves particularised sums and the 2 million loss of business. I understand the basic calculation for the 2 million loss of business, which in broad terms is 3 years at 2,500 dirhams a day on a gross profit basis, from which there will have to be deductions from monies which have been saved. So far as this is concerned, so far as the fraud is concerned, I also understand the essential basis of the fraud which is alleged, which is limited to 2 respects. One is making statements to the effect that the project would be finished within a defined limited period of time, which will need to be properly particularised on the basis that there was no real belief that they would be finished within that time. And the second is in producing post-dated checks, producing checks from an account which had been closed and which therefore couldn't provide security. So I understand the nature of that case. I'm going to be making an order that that case be clearly set out, but I'm going to permit the case to continue. I'm also going to find, albeit I have to say with some reluctance, that this case will have to continue in the court of first instance because I think that it's not right to strike out the 2 million claim for loss of business, although, as will be apparent, it seems to me that it is a surprising claim to be made. So far as the defence is concerned, I understand the defence to be taking a point that the Dubai courts have already assumed jurisdiction in relation to this, and that there is a res judicata, that is a final and binding decision in relation to it. I'm going to be making an order that that defence be properly set out within a defined period of time. And I'm going to be making an order that the Mr. ATUL reply to that within a defined period of time. I'm going to be making an order and expressing the view that it would be desirable if this claim is settled, and that therefore I will be making an order for alternative dispute resolution in accordance with Part 27 of the DIFC rules. In relation to document production, I'm going to be recording that both of you say that all documents can be produced within 28 days from today, and I'm going to be making an order that you produced all the documents you want in relation to the dispute within 28 days from today. In relation to witnesses, I'm going to be recording that each of you is in a position to put forward witness statements, I'm going to allow a period taking into account the desirability of this case being settled for the witness statements to be put forward. And in relation to expert evidence, I'm going to be saying that if either side wants to rely on expert evidence, they've got to identify the nature of the expert, and identify what that goes to, and produce a draft of the report so that can be considered. I'm then going to be saying that given that you're both in person, it will be appropriate for there to be a further short case management hearing in order to decide when this trial should take place and how long it's going to be. And the timetable will be set out in relation to those directions. Now, that's what I'm going to be doing. So the case will proceed towards a trial. It will be apparent that there will be some quite important issues, in particular in relation to whether or not the parties have effectively already had a binding judgment from the Dubai courts. But otherwise, the case will proceed to a determination unless you two gentlemen decide, to use the words I used earlier, to bang your heads together and see if this whole saga can be brought to a conclusion. Now, any questions arising out of that, what I've just said?
No, I'm quite clear with what you've said, and I understand it. I'm okay with everything what you said.
Mr. Ramzi?
Yes, but just a question. What about the decision done by Dubai court? What will that?
Well, you're, as I understand, saying that this whole dispute has already been decided by the Dubai courts. That's what I understood you
for
to
the
be
same
saying.
case, same parties, same everything.
Yeah, no, and I'm going to be ordering you to provide details of that in a pleading. That's what I said at the beginning. And I will then be considering whether that's right or wrong in due course. I'm not deciding that issue now. I'm just identifying that that's an issue which you want to put forward, in the same way that I'm identifying as an issue which Mr. ATUL wants to put forward, the allegations of fraud. But I'm sure you don't accept that those allegations are true. I'm just, at the moment, I'm laying the table. I'm not eating the meal, if I can put it that way.
Yes. All right.
All right. Do you both understand where we're at in relation to this?
Correct. I do.
Yes, thank you, Your Honor.
All right. Well, you'll get written directions in due course, and brief reasons as before. All right. Unless there's anything else, and the cost of this will be costs in the case. Unless there's anything else, I will finish this hearing now, and I may or may not see you in due course.
Thank you for your
Thank you very
time.
much.
It was a pleasure
Thank
to
you.
talk to you today.
Thank you.
Thank you.
Thank you, Leon.